Well, welcome everyone to this History and Policy online panel discussion on the Equal Pay Act 50 years later. Thanks so much for joining us. I can see there are people still coming in, but I think we should probably make a start. So I'm going to hand over to Professor Susan Milner from the University of Bath, who will introduce and chair this event. So Susan, thank you.
Hi everyone, welcome to this event. Thank you, Philip, and thanks to the University of London for hosting this via the History and Policy.
Just to ask everyone to mute themselves. Thank you.
I was also going to remind people about that. A few housekeeping things quickly, and we are still having, I think, a few people entering the room. First, to note that the event's being recorded. We hope you're all okay with that. The aim is to make this available via the History and Policy Forum website. Our next event for the History and Policy Forum is an in-person event on the 30th of October, and it's on the theme of industrial/employment tribunals. So a theme that's not a million miles away from tonight. I think this may be something that is of interest to people here. There was a notice that went out in the Bureau newsletter, which also advertised this event for those of you who are Bureau members. If you want to know more about the events, look at the History and Policy Forum website. So as Philip said, please keep muted. We've had some very weird noise events in previous seminars, which we'd like to avoid this time. Leave the video on if you can, because it's just nice not to have lots of blanks at the top, and especially later. So the aim is that our speakers will speak for up to an hour. We'll see how things go. We want to allow plenty of time for questions within the hour and a half that we've got all together. If you can't wait to ask a question, you want to leave a record, please do use the chat and we'll try to keep abreast of that, and then I'll remind people later when we get to the questions what to do if you want to ask a question by raising your hand and speaking in person. That's quite nice to do as well. So that brings us to the theme of tonight's discussions, which is equal pay, and this question of why it has taken so long to get the progress we've had. We have had review after review. Each review concludes that our legislative framework isn't fit for purpose, makes recommendations around a more proactive approach, around moving away from this individual approach, around strengthening enforcement. We're not there yet. And of course, the Labour manifesto last year made a number of promises for proposals in this respect. We've had a call for evidence this year. So this is something that's very topical. There's lots of proposals around what needs to be done. And the question is, we need change. How? And how, in terms of political capital, can we get the sorts of changes that we want? So we have two speakers tonight who are really well qualified to tackle some of those questions. And you will, of course, come with your suggestions and questions as well. We have Megan Fisher, who is an organiser at GMB Union, which has done a lot of work in this area over the years and has been involved in a lot of the really big equal pay claims involving local government in particular. Megan will be able to tell us a lot about these recent campaigns and also address this question of why it takes so long, because it seems mystifying from the outside. We're talking years, you know, if not well over a decade in many cases. Our first speaker is Sally Brett, and Sally, again, is really well qualified to answer some of these questions that I've already raised. Sally was a policy officer, then senior officer on employment rights at the TUC, senior officer between 2009 and 2016, so at the time that the Equality Act was adopted, leading on anti-discrimination law and equality rights. and fed into some of these reviews that I've just alluded to very briefly here. So I emphasise, and Sally probably will as well, that Sally's speaking in a personal capacity at this point. She's not with the TEC anymore. We need to bear that in mind. But please, can I thank the two speakers and welcome first Sally to address this question of equal pay.
Thank you. So I don't know if you could share my slides, or Philip could. Thank you. As Sue has very kindly introduced me already, and said that I am speaking in a purely personal capacity today. I worked on equal pay and gender pay gap issues for a very long time. I think as well as being an officer at the TUC, when the Equality Act was coming in, doing all the policy work around that. I also then went on to work at the British Medical Association for about 3.5, 4 years, and joined just following the 2016 junior doctor strike, when the gender pay gap in medicine had been an issue, and was part of the gender pay gap in medicine task force that was set up as part of the implementation agreement following that 2016 strike. And then also spent a couple of years at the Law Society, where I also did some research looking at the impact of the gender pay gap reporting regulations on law firms and their practices. But as I remind you again, I am speaking in a purely personal capacity, and health warning too that, you know, it's been a few years since I've worked with trade unions and in a national policy capacity. So I guess I'm the sort of historical speaker. Megan, no doubt, will have a lot more sort of up-to-date knowledge of what's going on at the moment in both litigation and sort of policy discussions at national level. But it's really interesting for me being a bit on the sidelines now, because I see things being reported and proposed that, you know, having been around a long time, I've got some personal views on, which I will maybe share later, and throw out some comments and questions too. If you could go on to my first slide, Philip. I should also apologise up front, but I had a bit of a laptop malfunction, and so I borrowed my teenage son's gaming laptop. So if there's any weird noises along the way, I've done something wrong, and I apologise for that too. So where did it all begin? Well, obviously, as you will, I'm sure, all know, because it was immortalised in the film Made in Dagenham, the Equal Pay Act began with the Ford sewing machinist strike in 1968, where the female machinists were striking as they realised that they were paid on the low unskilled rate, and they quite rightly saw the sexism and the undervaluation of their skills, and were demanding equal pay with men on the rate above them. For me as well, I began work as in the late 1990s as a pay researcher at Incomes Data Services, and we began showing an interest in gender pay gap, and had the pleasure of meeting many of those machinists at a Wainwright Trust evening many years ago, and I remember actually when I was leaving IDS that photo of the women striking, voting for strike action at Ford was on my leaving card that everyone gave me. And I absolutely loved that photo, because to me it really showed the sort of the joy and solidarity behind that campaign as well, which was, you know, later really captured in the film. At that time, it was late 1990s, 2000. There was a real push by the Equal Opportunities Commission and by the then new Labour government, around 30 years of the Equal Pay Act, and frustration that more progress hadn't been made, and sort of beginning realisation when some of the really big sort of equal pay cases that were taking years to resolve. They were sort of questions around why it was all taking so long. There was a real push to look at what more could be done. And the Equal Opportunities Commission in particular set up a national equal pay task force that did a really big and I thought very good piece of work, trying to encourage employers to take more steps to audit their pay systems and ensure that they were providing equal pay for men and women. And following that, there was also the government then commissioned the Kingsmill Review to look into one of the main EOC task force recommendations, which was that employers should be required to do mandatory equal pay audits. And that sort of supported that approach, but said initially there should be a voluntary approach. And potentially, if there wasn't enough action by employers, that further down the line, a mandatory approach should be considered. So there was quite a lot of activity, particularly amongst some of the large employers back then. And I went on as well to do research on behalf of the EOC to look at how many organisations were doing equal pay audits and the progress that was being made, and also did a sort of a series of case study research as well for some companies on the quality of those equal pay audits and how well they were being done and what was coming out of it. And it felt like a really active time, and it did feel like there was sort of progress being made and some attempts by good practice employers to really do the right thing. And it's interesting because I feel that was perhaps a moment missed and could have been built on more, and we may be coming back round to revisiting, in particular in the EU, the importance of doing equal pay audits. It was also really interesting. I was reflecting back then because when at that time in working for IDS, every year when the new earnings survey, as it was called then, now it's the annual survey of hours and earnings, came out every year in the autumn, we sort of competed to be the first ones to calculate the gender pay gap and put out a press release. And at that time, the ONS really didn't like us doing that because they thought it was a bit of a flawed statistic because it wasn't comparing like with like. The very sort of purist statisticians didn't like the measure. But over the time that I was there, it was sort of interesting that the ONS built it into their annual release, and often it became one of their sort of key headlines or points around that annual release. I've just before I move on, I put a link in at the bottom there. I checked, it is still there, but the TUC at that time did a really, really good piece of work to build an equal pay archive. And it's still online. And there were lots of, brilliant documents, policy documents and interviews with women and trade unionists who have been involved in various legal battles for equal pay and campaigning for equal pay. So if you want to find out more about the history, I'd really recommend exploring that resource. So if you move on to the next slide. I haven't got the next slide. Could you move on, Philip? Or is it just my screen that's frozen?
No, it's sort of being temperamental.
Okay.
Yeah.
Thank you. Sorry. I always think it's my fault when things go wrong technically. So just a brief overview of the Equal Pay Act when it was first drafted and introduced in 1970. It provided the right to equal pay for men and women doing the same work, same or similar work, or work that was rated as equivalent under a job evaluation system. unless there was a material factor that was unconnected with sex that could explain the difference in pay. Now, employers were given 5 years to implement equal pay, which meant that it didn't come into force until I think it was December 1975. And one important thing is that to note is that the drafting of the Equal Pay Act predated the drafting of the Sex Discrimination Act. So because of the strike action by the sewing machinists at Ford and the Equal Pay Act being something that came out of that at policy level to address urgently, and that was drafted first and was very focused on finding a solution to that issue. And then later, the Sex Discrimination Act was drafted. The reason I say that is because the Sex Discrimination Act, when the Equal Pay Act was drafted, there was no real understanding of things like indirect discrimination, or the distinction between direct discrimination and indirect discrimination. And over the years, it has been led to some quite complicated, case law, as the indirect sex discrimination was read into various parts of the equal pay provisions. And I actually ended up, when I did my master's in employment law, doing a whole dissertation on indirect sex discrimination and the equal pay provisions. And that's part of the sort of real complexity around the law, which I'm sure Megan will talk about later as well, about all the complexity of how the law works in this area and why it can be so difficult litigating. One thing that was really interesting to note when I did my dissertation, I remember going back and looking at the impact of the Equal Pay Act in the first few years after implementation. And you saw the gender pay gap narrowed by 15.4 percentage points in those first 7 years. I did a calculation of, about a decade ago or more, when I did my dissertation, about what a difference it had made in the years subsequently to the overall gender pay gap in this country. And actually, I've gone back and updated that, and you found that in the past 25 years, the gender pay gap has narrowed by just 7.8 percentage points. So in those first 7 years, the pace of change was about 7 times what it has been since. And that's no surprise, really, because in those first years, it really addressed what was really overt direct discrimination. So it eradicated the male and female rates, for example, that had existed in a lot of employers. But also, when it was first introduced, there was a collective mechanism to level up women's pay to men's rates in collective agreements. So if an employer hadn't acted immediately or acted in those first 5 years, then the industrial court, or what's become the collective arbitration committee court, the CAC, could automatically increase the female rates to women's pay up to men's rates. But that only lasted for a couple of years, I think, because there was the CAC, when it did intervene, there was you sort of saw the unease about courts intervening to determine pay rates and go against perhaps what employers or the market might have determined. And I think that resistance to courts or tribunals determining pay rates and imposing levelling up is still part of the very sort of long, difficult battles there are for equal pay today as well. If you wouldn't mind moving on to the next slide. Another really important point to note about the first Equal Pay Act, the first drafting of the Equal Pay Act, was it didn't include a right to equal pay for work of equal value. which was a really, really significant omission. So it meant the original Act didn't address the historic and systemic undervaluation of the types of jobs that women do in the marketplace. So, for example, the perceptions and stereotypes about jobs like caring, cleaning, they were often, or have often been, seen as not that skilled. They're sort of seen as the kinds of thing that women just do intuitively, or as well that there were all those stereotypes, the sort of long legacy of stereotypes about a man's wage being a family wage, because men were the main breadwinners in family while women just went out to work for pin money. I found a really lovely a quote that really highlights this, from a Belfast cleaner in one of the TUC archive interviews, who was involved in one of the big NHS cases, where she said there was a perception from managers, and even male managers would say, that the women cleaned their own homes, so coming in to clean the hospitals was no problem to them, because that's what they've done all the time. They didn't really need as good remuneration as men did to come in and do jobs of similar effort and skill. And so it wasn't until the UK joined the EU and joined the European Community, and the EC introduced an equal pay directive, building on the right to equal pay that was in the original treaty, that the concept of equal pay for equal value was introduced into European law and then introduced into UK law. But it was only introduced into UK law in 1983 following legal action by the European Community against the UK government, because the UK government had been very, very resistant to recognising it in the Equal Pay Act. So it was introduced in 1983 in the UK, and some thought that at that time that it would have really transformative potential, and really, again, kickstart the next wave of ensuring equal pay for women in this country. However, it did lead to some really important equal pay cases, but those initial equal pay for equal value cases and the ones that have followed have become really lengthy pieces of litigation. One of the really important cases, the speech therapist case in the NHS, took 15 years to be resolved. And also, you still had the material factor defence to equal pay for work of equal value claims. So that was an opportunity for market rates to come in as a potential defence again. And there was real, still, I think there's a real theme of resistance to going against what the market might be setting, and also the potential costs of large-scale levelling up of women's pay to men's pay. So that has led to real resistance, and when some of these big multiple equal pay for work of equal value cases have been launched, you tend to get employers defending them at every step, defending them in the initial stages where there's attempts to establish equal value, and then if equal value is established, then trying to defend them at the material factor stage as well. Move on to the next slide. Another point that I wanted to pull out, because this was definitely a feature of my time when I was at the TUC, and we were campaigning for and lobbying for the Equality Act. That coincided with a lot of litigation that was happening in local government. And one of the things that the features that really came out then was that most of the equal pay litigation that was going on reflected a problem in collective pay systems. But the legal remedy was an amendment of an individual contract and back pay compensation for an individual. And there was a very strong, and there is a very strong individual right to equal pay for equal work. And there was a real challenge, I think, at that time, sort of from the 2000 onwards, when we started seeing these really big multiple equal value cases. And also there had been changes that had extended back pay compensation to up to 6 years, which had added to the potential costs of settling these cases and levelling up. So they were very sort of fiercely defended. There was lots of litigation going on by the unions on behalf of members, and also by no-win, no-fee lawyers on behalf of individual women too, by no-win, no-fee lawyers against some of the unions as well, because on the basis that they hadn't taken sufficient action to litigate the women's rights to equal pay. And at the same time of all of that happening, we were still trying to work out how we negotiated an actual equality-proofed pay structure. So, and with the pressures on public sector pay and the difficulties in getting more public funding for settling some of these cases, it became a really, really thorny policy problem as we were going into the Equality Act. And there was all sorts of talk and exploration about how we could improve equal pay law, reform equal pay law. I've put a link there to an article from Professor Sandra Fredman, which I think she was the person who an academic who gave it the sort of deepest thought and the best attempt at coming up with alternative solutions and trying to establish more of a collective legal remedy. She proposed going back in a way to perhaps what had happened under the original Equal Pay Act, and it being an individual may be able to trigger a collective remedy and an amendment to a collective agreement. So lots of thinking went on. But what we ended up with, I think because of quite a lot of risk aversion, maybe quite rightly, because there was so much litigation happening at the time and no one quite knew where it was going, we ended up with just a lift and shift, basically, of the Equal Pay Act into the Equality of Terms section of the Equality Act, with a couple of amendments, but not as significant, not that significant. So, and a lot of the sort of case law was read across. I think there was fear about unpicking some of the established case law too at that time if we'd changed things too dramatically. If you go on to the next slide. One of the issues that was raised again and again and again when we were looking at equal pay law reform, and also went back to what the EOC Equal Pay Task Force had said in 2002, was the lack of pay transparency being a major barrier to establishing the right to equal pay. And it's a major reason as well, I think, for the lack of action in sectors where there's highly individualised pay setting and there aren't very clear pay structures. And so people just do not know whether they're being paid less than a colleague. They often also, without a structured pay system, they don't know if they're doing equal work to a colleague. And also, you know, if they do think they're being paid less than a colleague and they were to challenge it, an employer might put forward what could be a material factor defence to that or explanation of that, but there's no way to really scrutinise it. So we talked a lot at that time about, I remember raising again and again, the lack of pay transparency being a real issue. Now, just say before I go on to talk about what came in response to that, that the EHRC, as it is now, Equal Pay Code of Practice, clearly defines transparency as meaning that pay and benefit systems should be capable of being understood by everyone. Where the pay structure is not transparent and a woman is able to show some indication of sex discrimination in her pay, the employer carries the burden of proving that the pay system does not discriminate. So that really emphasizes to me the importance of transparency, meaning having a structured pay system with clear criteria that any person in that workforce could understand. If you could move on to the next slide. What we got from raising concerns about pay transparency was gender pay gap reporting. And Harriet Harman, there's a quote here, I remember being in meetings with her talking about this, and I should say that the TUC and the trade union calls for more transparency were also around picking up what had been going on in the 2000s post the Equal Pay Task Force, which was the need for mandatory equal pay audits, which we thought would also encourage more employers to make sure that they had structured, properly job evaluated pay systems, and that they were regularly auditing them to ensure that there was equal pay for men and women under those pay systems. Now, Harriet Harman refused mandatory equal pay audits, and I found a sort of fairly recent interview with her as well, where she said that they wouldn't have moved the needle on equal pay, and that a simple gender pay gap figure was what was needed to empower people to say that we've got to change what we're doing. David Cameron as well was the Prime Minister who brought in the gender pay gap reporting regulations. And I remember him rather grandly saying that they would cast sunlight on the discrepancies and create the pressure we need for change, driving up women's wages. Now, I would say I do genuinely think that the gender pay gap reporting regulations have created pressure within companies and put gender equality firmly on the agenda of lots of companies, particularly the larger employers who strive to be, good practice employers. But I'm interested to see what impact they've really had in practice. And surprisingly, given how many years on since they were introduced, I think it'd be about 10 years next year, but I haven't seen a lot of research into this area to look at the impact that they've had. I've picked up a piece of research by Aon, who about 6 years after they were introduced said that they thought the impact on the gender pay gaps had been very limited. When I was at the Law Society, we did a piece of research to look into what impact they'd had over the first 5 years, and found that of the 40 largest law firms over the first 5 years of gender pay gap reporting, we'd seen the mean gender pay gap had decreased by minus 1.38 percentage points, and the median gender pay gap had actually increased. And more recently, I've seen the wonderful Dana Dennis-Smith, who began the 100 Years of Women in Law campaign, has done loads of work to campaign on gender equality in that sector, talk about how they were left fiddling with percentages and firms are in a vicious circle of, doing quite a lot of work to calculate their gender pay gap each year, and then explaining things away as they tried to understand what might lie behind it. And I would say as well, having done work with various companies looking at gender pay gaps, you end up doing a lot of work calculating gender pay gaps, and then you're without sort of a structured job evaluated system behind it, you quite often are left, trying to work out the causes of it. And it's quite people in law firms said to me once, it's quite a messy indicator to go after, because you're trying to work out what might lie behind it. Carrie Gracie as well. I've heard, it sort of said sometimes that the transparency. I think Harriet Harman said it in her interview, that the transparency that was introduced with gender pay gap reporting had led to people like Carrie Gracie realising that there was potential equal pay claims there. But Carrie Gracie was aware that she was paid less than a colleague when the BBC was compelled by the Royal Charter to publish salaries of the highest paid staff. So that was when she actually saw there was a potential higher paid comparator than her that led to the equal pay litigation in the BBC. So moving on to the next slide. As I said, I'm not, as over the detail of what is currently being proposed in different areas or involved in policy discussions at national level anymore. But to me, what I see being proposed is more pay gap reporting, extending it to ethnicity and disability, and with the possible introduction of action plans as well behind it. I would question, as I said, I find it interesting that we're sort of the policy discussion is focused on extending it to other characteristics when I haven't seen, I don't think, a really robust impact assessment of the impact it has had. We're also, I see, talking about extending there's been talk of extending equal pay provisions, the equality of terms part of the Equality Act, to race and disability, which I find, when I've seen that reported, I've found that very interesting, because one of the more radical suggestions back at the time of the Equality Act was that we actually completely got rid of the equal pay provisions, the equality of terms section, and we just allowed sex discrimination in contractual pay and terms and conditions to be addressed by more straightforward direct or indirect sex discrimination claims, because that would get rid of some of the challenges there are in finding an actual comparator doing equal work to you who's paid more than you. And I think it will be particularly challenging finding actual comparators of different ethnic, particularly on the disability front, because quite often you don't know if a colleague has a disability or not.
Mm.
Finally, the EU Pay Transparency Directive as well, which is coming in next June, I think that is much closer to what we were raising around the time of the Equality Act, when we were raising concerns about a lack of transparency. And I see under that, as well as some gender pay gap reporting, there's also, if you find that there's a pay gap of over 5%, it's recommended that a full pay equality audit is done. There's rights for employees to get information about the average pay of workers doing similar work to them, rather than just what we have with the gender pay gap reporting, which is a gender pay gap for a whole company. There's also requirements to disclosure of salary information before hiring and salary ranges. So much more akin to what is in the statutory equal pay code of practice around transparency. And then my very final points, if you go on to the next slide, sort of final thoughts from me, sort of having stepped back from this a bit in recent years, is and looked at it again in preparing this tonight, is that I do think the Equal Pay Act was really transformative in the early years. I think the equal pay for work of equal value hasn't fulfilled what some said was the promise of, real transformation when those initial provisions came in. That's not the fault of the right, it's the difficulties of enforcing those rights, establishing that there is equal value, and the sort of ferocity with which that has been resisted as well in all the legal battles. On gender pay gap reporting, I think it's put gender more firmly on the agenda for many employers. as maybe become apparent, I'm a little bit skeptical about how transformative that has been in actually levelling up and improving women's pay and conditions. And I think I have actually seen other interventions, like the introduction where I've seen better, more equal paid parental leave being introduced, for example, or more support with care and family responsibilities. I've seen that have more of an impact in how men's and women's work is valued and men's and women's roles within the workplace. And I wonder if those kinds of things actually have more potential to improve women's pay and employment opportunities relative to men in the future. Sorry, I may have talked for a bit longer than expected there, but thank you.
Thank you, Sally. Yeah, we've overrun a little bit, but I didn't want to interrupt because genuinely it's really interesting to hear you reflect on those discussions that were had in TUC at the time of these really key moments and what the missed opportunities were. Are we ready to? We'll take questions later, but are we ready to move on to Megan's slides?
Absolutely. We'll share my screen. View. Let me know when you can see it. Hopefully, we'll take a minute to load. Oh. That look okay? Okay, great. Thank you. Thank you, first of all, for having me tonight. I think it would be a really interesting discussion to get into kind of after my slides as well. And it was really, I learned a lot actually from what Sally had to say, and lots of it's obviously very familiar, but absolutely fascinating. And I think there's a lot, yeah, we could kind of dig into around that as well. By way of introduction, my name's Megan Fisher. I work for GMB Trade Union in our women's campaign unit. I'm trying to jump right into the slide. So a bit of background around the work that we do, and then I'll give you a bit of insight into kind of the landscape of equal pay in an industrial sense. I will caveat, I suppose, initially that I'm not a lawyer. So some of the kind of super technical legal arguments are probably, I'll try my best on, but yeah, we can have an interesting debate on them potentially from an industrial angle as well. So in terms of what we do at the Women's Campaign Unit at GMB, currently we're supporting 100,000 women across the union to support them in their fight for the right to equal pay. That's all the way from employers like ASDA in the private sector and a couple of other private sector claims to a lot in the public public sector and local government as well. We work really closely, obviously, with our national legal department and have quite an interesting time talking about the nuances of equal pay legislation and what we can do to improve it, and constantly looking at ways that we can support our members best in their fight for equal pay with the legal side of things as a tool to help us in our campaigns. So we provide our regions with support and training advice toolkits. And one of the things that's best is that we kind of oversee all of the regions, so we can see what's happening in one campaign and one claim and how that translates into another, and try and use best practices to help support our members in achieving pay justice. My job is really to help plan and develop campaigns and support members again in their fight for equal pay. So all the way from kind of the time when somebody brings an issue to us and they think, I think this might be an equal pay issue, or they tell us that, you know, what's happening in their workplace or what conversation they've had with a colleague or with an organizer, all the way through to we're now at the point where we're starting to finally settle a couple of the campaigns that we've launched in the past probably 5 or 6 years since we launched the Women's Campaign Unit. And then Sally touched on it as well in terms of mass litigation versus individual litigation and claims. We focus mainly on mass litigation and mass campaigns. And we do obviously still support members with individual claims, but we kind of look at it from a high level and what impact that has on policy and how we can kind of make the most change for our women members across the union. So I thought I would add in a couple of pictures around, I guess, and give you a bit of background around bit of background around my journey around equal pay. I started with the union right around the time of the Glasgow equal pay strike, so it was not long before that, where I came into the union and started to learn about really how unions work, what we do, and about the fight for equal pay. I think this has probably been the pivotal moment in GMB, and I think it's probably now becoming almost the catalyst for what we're calling it kind of single status 2.0, which is where, if you're familiar with the background of equal pay history in local government, when different pay structures were changed in the 1990s and 2000s, where there were multiple books and multiple paying arrangements and terms and conditions were all amalgamated into one that's commonly is referred to as single status in local government. There's a huge wave of equal pay claims. Lots of you will probably be familiar with Stephen Cross as well, and his role in that period of time, and the hundreds of thousands of claims, if not more, that he supported and that were going on at the time around the country. So Glasgow was actually as a result of that. So Glasgow was a more than a decade-long fight, and it actually, I think maybe there are still some councils, I think, who are still implementing elements of single status. But for us, it was quite a pivotal point where it brought equal pay back to the forefront of what the union was talking about and what the union was focused on, and where we were kind of focusing our energy and our campaigning efforts to support, especially women members, but all of our members. The kind of follow-on from that was the development of at the time it was the sex discrimination unit, and it's kind of formed into the women's campaign unit. And as the Glasgow strike and the kind of first wave of settlements were starting to conclude, we had a thought internally, and we had some conversations internally about, is this happening other places? Is it possible that equal pay is still really an issue around the UK and around the country? And I was based in Glasgow at the time, and we started to look around other places and think about what other sort of equal pay issues could still exist. And we found, we've not stopped finding issues really since then, to be honest. My experience has been that single status happened, and after conversations with people like Stephen Cross and people involved in single status at the time, one of the things that never really happened was fixing the problem. I've got a bit more on the slide later on as well, about how issues were raised, women were paid out, big payouts were made to a lot of people, and then the issues either crept back in or just were never really addressed. It wasn't the goal, it wasn't the aim or desired outcome necessarily for private lawyers, especially no-fee lawyers, to go in and fix the problem after. You can see how they come in to fight the claim, they get a good settlement, a good outcome for their claimants, and then they move on. And one of the things I think the unions really struggled with, and there's everywhere's a little bit different, obviously, but we never really fixed the problem and continued to ensure that equal pay issues didn't creep back in. So fast forward to Glasgow and 2018 onwards, we've started to look around again and see what is happening, where are things at. Even if you look back actually at issues, the exact same pleaded claims we're pleading again in a lot of places. It's almost a rinse and repeat. A big part of our campaign, a big part of my job is ensuring that in 10, 15, 20 years from now, we're not having single status 3.0, that we're not continually underpaying women for decades, years and decades. And if you've been involved in equal pay, you'll know that lots of times our women members pass away before they achieve equal pay. So it's not something that we can kind of sit back and expect to happen. It's something that we always have to be going after and achieving and ensuring that issues don't creep back in. Unfortunately, we live in a society where women's work is still undervalued. And until there's a major shift societally, I think that we always have to be actively looking, always have to be seeing what's out there and who's in receipt of what terms and conditions and pay, and ensuring that women are paid fairly and are paid equal pay. So fast forward now to the past few years. Birmingham is probably one of our biggest campaigns. I think it's probably our biggest campaign at the moment, where kind of as a direct result from Glasgow and all of the issues that we're starting to find since then. Birmingham is a result of that. Interestingly, if you're not familiar with kind of the history of Birmingham, there's quite a lot of history, so probably wouldn't be able to give you all of it. But in terms of GMB's role and my role in the campaign and kind of getting to where we are today, and I can talk about that, where we are today as well. One of my colleagues, Rhea Wolfson, was one of the lead organizers in the Glasgow campaign. And as we started to look around, we started to find campaigns and more issues in Scotland, and we started to look more widely across the UK. And it just actually happened to be after a conversation with one of our colleagues, and just on a tea break at another meeting, where one of our organizers, Michelle McCrossan, said, I'd like to speak to you because I think there's maybe something happening in Birmingham. And she said that to Rhea. And Rhea said, okay, well, what is it? Like, what do you think is happening? And Michelle said, there's a nuisance payment going out to members that the council has offered, and it feels a bit off. There's something a bit fishy about it. I'd really appreciate if you had a look at it, and if we could see that and make sure that there's nothing going on that we need to be worried about. And that was literally the start of the current equal pay wave of settlements in Birmingham. The nuisance payment was essentially a buy-off of all of the trade union members in the council, asking women to sign away their rights to equal pay, all while there were issues around task and finish, which I'll talk about in a minute again. There was inflation of male-dominated jobs, and fast forward to today, we have an agreement where £250 million will be going out to working women in Birmingham, because one of our organizers thought something was a bit off in an agreement. So that's really kind of the snowball effect, I think, and I hope we're having internally in GMB, is just raising people's awareness around what's happening, and looking again just to make sure that there aren't any issues, or taking our time and thinking about the impact that one agreement can have on other groups of workers. I think that applies across the piece in terms of equalities work, when you're going in and looking at in terms of a trade union's kind of perspective on things, and our role in supporting workers is when we're going in and we're talking to members about one thing, and we're fighting or to retain terms and conditions or pay or improve it, that we're thinking about how that impacts everybody else, especially women, especially global majority, especially those with disabilities. And that's how we reduce those gaps. And as a trade union, that's how we can actively start to fight against some of those things. So in terms of what we have currently happening at the moment, so lots of our work is to do with local government. So Dundee City Council is actually the first campaign we found after after Glasgow, and kind of the snowball effect from there. So Birmingham is one of our biggest campaigns, which we're hopefully nearing the end of the settlement process to get members the money that they're owed, off the back of an agreement that we made with the council last year. We're looking at issues in Leeds, Coventry, Cumbria, which is now Westmoreland, and Furness and Cumberland, Brighton, Blandygwent, which is settling currently at the moment. And we have about 30-ish other campaigns that are kind of happening across local government. So this doesn't include private sector. So I guess, again, that's kind of what I mean around single status 2.0. Like, we're literally reliving the issues of the first wave of mass equal pay claims in local government. And yeah, we're very mindful, and we're very conscious of fixing the problem and putting that work in now, so that women are underpaid again for another 10, 15, or 20 years. And we know that not everyone will see equal pay in the end. So I can talk in more detail about some of those campaigns as well, if you like. I thought it'd be helpful as well just to talk about some of the red flags that we see. I think when we talk about how does this keep happening, why is equal pay, why is it such an issue, why is the gender pay gap not narrowing? I think there's lots of, it's not just this, but I think I've seen blogs and kind of reports around an unknown part of the gender pay gap. And for us, it lies squarely in discrimination and unequal pay. And it's really quite stealthy. I think Sally's spot on in terms of the most obvious issues. Those were those were kind of dealt with already. If you go into a workplace and you are an accountant and your colleague's an accountant, it depends on where you are, but in terms of anywhere there's pay transparency, it's less likely that those people will be paid differently. But there are a lot of really kind of creative ways that we find equal pay and unequal or equal pay issues creep in. So I guess the campaigns that I just talked about are all, these happen in lots of them, and multiple issues happen in pretty much every council where we have found equal pay issues. So pay protection is one. Indefinite pay protection is you're just protecting discriminatory pay for an indefinite period of time. It's not pay protection at that point. You're just keeping somebody's wages inflated, most likely, and not rectifying the issue. Bonus schemes are a really interesting one. So Dundee is bonus schemes. The claim in the campaign in Dundee is around craft workers who receive quite substantial bonuses to top up their kind of core salary. It seems like kind of a more obvious one, like if we do the same job and you get a £1,000 a month bonus on top of it, that's not checked on, it's not given for any specific reason. There's nobody kind of regulates it in any way. It essentially becomes core pay. So bonuses can be quite a big red flag for us, especially in local government. Again, for unjustified labor market supplements, that's something that can be quite a big red flag for us. And if they're not maintained, if there's not legitimate justification for the supplement, then it's an easy way for one group of workers to be paid more than another. Job creep is an interesting one in this. It links really closely with equal value. And Sally covered equal value really well. And yeah, it would be good to dig into that a bit more as well, because it's one of the principles where politically we're quite concerned about that being under threat. And for us, it's incredibly important, and it's obviously a very core piece of equal pay. And I think the gender pay gap is really impacted by that. Job creep is one where we find a lot of equal value issues. So when I say job creep, I mean, for example, like care workers, their jobs often creep up. So the responsibilities, the tasks, the things that they're asked to do, so the knowledge that they have, the working conditions can sometimes deteriorate, but it makes the job harder. All of these things kind of add up. So if you look at a job valuation scheme, they will potentially be 1 or 2 levels up, but their job has stayed at, say, for example, a grade 3. But if it's crept up slowly over time, and they're actually doing work of a grade 5 or a grade 6, that's really, really common. And it's something that is hard to identify because it happens slowly. I think it's normalized in a lot of female-dominated workplaces and kind of sectors where you just do the extra 15 minutes. You stay and help kids after school because they need it, and you add extra responsibilities, and you're teaching phonics, you're cleaning up the paint pots, and you're doing social work in some cases, and it creeps up over time, and people don't often kind of step back and look at, is my job valued how it should be, and not how it was 5, 10, 15 years ago. Implementation of a scheme is quite an interesting one as well. This one reminds me of Fife. If you're interested in equal pay, equal pay judgments, the Fife judgment is a really fascinating one that happened maybe 2 years ago, maybe a bit longer. Throughout kind of our ramping up of equal pay campaigns and claims, Fife happened right in the middle, and has kind of become, I guess, infamous in some ways instantly. So if you're interested in long justifications around judgments around equal pay, Fife is one I would recommend you look at. It's ongoing, actually. It hasn't settled yet. The implementation of the scheme is being discriminatory was a big feature of part of that judgment. And it's quite long and it goes into a lot of detail, which is a theme as well going throughout equal pay, because it can be quite big and complicated and contain lots of detail. One of the things that came out in the Fife judgment was that the job valuation scheme and pay and grading systems were implemented under a cost saving kind of agenda for the council. So one of the things that came out in the evidence was, interestingly, is an email between the job valuation team and HR. And it was the job valuation team emailing HR saying, good news, a big group of care workers, or a big group of female dominant workers got graded at a 3 out of 4. So don't worry. And the response from HR was, well done. That's absolutely grand. Good job for today, gold star. Obviously I'm paraphrasing, but when that's the guys that in a scheme where paying grading is implemented under, there's massive red flags, and we're looking at the work of those care workers, the work of those female dominated groups of just automatically being undervalued as a way to save money for the council. Whereas if you go to predominantly male dominated jobs, which are often our comparators, or waste and fleet, there's no sort of good job for saving money there. It's let the guys, let the binmen or the refuse workers go home early because, well, for whatever reason, you can, I guess, make up your mind on that one. Again, something like slow response for appeals is something we run into a lot. I don't think it doesn't automatically mean that there's an equal pay issue, but it's something that we find very often, where we'll have a group of women workers who, a group of members who have been going through an appeal process for 2 or 3 years, and not everybody has that same experience in that employer. It can be another cost-saving thing for the council. It will just take a really long time for them to appeal, and we'll get to the point where we will look for equal pay issues as a way to push them faster, into properly recognizing the work that group of members is doing. Grading structures can be discriminatory. Sometimes if we would look for something like a grading structure if there's a compression of female dominated jobs just below a grade boundary, we would look to that and see if we could challenge that and ensure that there's not, the grade boundaries aren't drawn in a way that it could be equal value arguments for just below and just above. And it happens to be that the group of women workers fall just below. That would be something that we would probably want to look into. Task and finish is a really big one. This is one that people like to debate a lot. So we may get some questions on that, but is a really big feature of a lot of our campaigns at the moment. If you're not familiar with what task and finish is, it's essentially where you do your work and you go home and you paid for your full shift. So again, something that happens a lot in waste and fleet and refuse. You do your round, maybe you start at 6 a.m. and you finish your round at 10 a.m. Great, you can go home, enjoy the rest of your day off and receive your full wages. Whereas in female dominated jobs and pretty much the rest of the council, that's not an option. We often find that care workers are staying late with their service users. Teaching assistants are staying late to support students and ensure that the school is running, and they don't have the option to leave early, like refuse workers often do. So that's a major feature of a lot of campaigns at the moment, and is part of the Birmingham campaign as well. Out-of-date job valuations comes under job creep as well as implementation. There's probably, and then lack of transparency, I guess those go quite hand in hand. If you can't figure out why you're paid what you're paid, that's quite a big problem. And if there's no transparency around how you're scored and why you're scored that way, which is really quite common, is an issue. If there's not a justification for why you're a grade 3 and not a grade 4, then there would be something that we would want to look into there. And again, there's a lot of themes that came out of the Fife judgment around transparency, which are quite interesting if you're interested. And to any group that will listen, I always say this, we deliver a lot of training across the union, and I kind of touched on it earlier. One of the things I'll always say to all of our members, all of our organizers, anyone who will listen, is that when we're talking to people about their terms and conditions, when we're negotiating anything, we're always asking, are women getting the same opportunity to earn as men? Are there any gendered assumptions built into a job valuation or paying grading scheme? And does it feel fair? And I think this, again, could apply across any sort of protected characteristic, probably. One of the interesting things is my first kind of training around job valuation was with Glasgow Equal Pay. And we were in job valuation training because of the equal pay campaign and for the implementation of a new scheme to replace the existing discriminatory scheme. And in a room full of trade union reps and members with a professional job evaluation expert training us. We did part of the training was around doing like a mock evaluation. So we had one job description that was for home care, and we had one job description that was for like an LGV driver. And the whole time, and it's nothing gendered in it. And even in a room where the whole point is to talk about and eradicate equal pay issues, we still had people saying she does this and he does that, but he does this and she does that. And it's so ingrained that even in the most kind of purposeful rooms, gendered assumptions creep in. And so it's not something that we can kind of take for granted. And it's probably the reason I have the job that I have, and we're doing the work that we do, is that it's not, people don't go in every day and say, I'm going to go and give this group of workers, better pay than the women. That's not what happens on a daily basis. It's not, what employers set out to do, but they don't think about the implications of what their practices result in the end, and how they impact on all of their employees and staff. So just thought I'd add that in. And then another kind of principle that we talk about a lot is bringing the women up and not the men down. And so I briefly touched on this as well. As much as we say that, reality is different. It means increased wage bills. It might mean redundancies. And that's a conversation we have all the time with employers is, we're not asking you to reduce men's pay. We're asking you to level women up. The reality is it is harder. It's easier said than done, I suppose. It's not impossible in a lot of places. And even where it is possible, and it's actually more expensive to bring the men down, sometimes we still find that there's issues around people accepting that we could just raise the women's wages. So yeah, that's an ongoing battle, and I think that's probably an ingrained assumption as well. Fixing the problem, like I said, is a huge part of what we're trying to achieve as a union. I don't want to be doing this again in 20 years. And I think when we look at the public sector, most of our time, to be honest, is spent in the public sector, but the private sector is untouched. There's the lack of transparency, and probably the pay inequality, I think, is probably astronomical, and will be a huge part of kind of the overall gender pay gap as well, obviously. And then finally, what part of our aim is always to build the union. We see that in our sustainability around ensuring that equal pay issues don't creep back in. If we need to keep building in female-dominated sectors so that women have the backing of a union, because it's extraordinarily expensive and extraordinarily time-consuming to challenge equal pay, and it's frankly impossible if you don't have a union behind you, or some sort of support. I think Carrie Gracie Sally spoke about as probably one of the very few cases you could take it on individually, and it wouldn't have come without significant costs. And then I always add in as well, like where there may not be a legal claim, there is usually a campaign for us. It's hard and it's complicated and it's challenging to bring equal pay claims. It doesn't mean that it doesn't exist. Sometimes we can't get a hold of the information. Sometimes the lack of transparency means that we don't have a claim because there's not enough legally to meet the threshold. There's always a campaign in fighting for fairness and equality in women's work. I think I touched on a lot of these themes already, and I think this is my last slide, so I will wrap up. A couple of themes is around kind of our experience industrially and equal pay is that members taking action is always the pivotal part of the campaign. In Glasgow, it was a strike. In Birmingham, it was a strike. It doesn't necessarily have to be a strike, but employers don't come willingly. They won't. Nobody willingly hands over tens of millions of pounds or any. To be honest, it's one of we talked about it as a human right that women have to sue for, and one of the issues again is employers believing that there's a problem for pay justice becoming a reality. They need to believe that there's a problem. Where we have the most challenges in achieving and fighting for pay justice, where employers generally don't think that they're doing anything wrong. And it's so hard to help people understand how they've created inequality and injustice in their own organization. And it's not personal. I think, there's some people who deal with or have dealt with equal pay problems better than others. But organizations fail. It's not just people within them. And sometimes people genuinely don't believe that it's an equal pay issue. And that is really challenging for us when we get into a room and we try to explain it for people, to people. And where they do believe it, there is a way that we can resolve it and that we can improve things. But there's a kind of a lack of belief sometimes that we find challenging. And I talked about this a lot throughout, but the court system being difficult and time consuming is probably our biggest issue. We try our best to stay out of the court system and stay out of the tribunal because it's too time consuming, it's extremely expensive, and it's quite complicated as well, obviously. And I actually had one more slide, and this is quite a big one, so apologies for that. In terms of our asks around the equal pay legislation, some of the big things that we have asked for and we've put in the consultation to the government is around a regulatory enforcement agency. So in terms of this, our aims are around being proactive. So similar if you think about like the health and safety executive, where, and actually it comes back to Sally's point, I think as well, around individuals raising collective issues that could be implemented collectively. There being enforceable job evaluation or mandatory job evaluation schemes for employers with over 250 employees, stronger pay transparency, taking some of the equal value litigation out of courts and putting it into a regulatory enforcement agency that has resources and the technical expertise. We find in actually in a recent hearing last week, a judge came into the hearing and said, I don't have the expertise for this, so I need to reschedule it, which has now delayed us 4 months. It's very easily racks up time. And we find those challenges in the employment tribunal system pretty regularly. Adding in injury to feelings is kind of an obvious one around you can claim for injury to feelings or have that as part of a remedy for discrimination claims, but not for equal pay. And then cross-employer comparators is an interesting one where we're looking at where employers like subcontract. So Dundee is a good example of this one, where there's a council that co-owns a company that carries out the work for the council. And it's completely publicly funded, but because it's like one step removed, we can't compare across. Similarly for schools, we struggle to compare across for academies and foundation schools and voluntary aided schools as well. So yeah, I can go into more detail about that as well if people are interested. And then finally, promise is the last bit, is I've put kind of in smaller print, but part of our, it's not technically a legislative ask, but part of our campaign to central government is for them to address funding in local government, because equal pay doesn't come without cost, job valuation doesn't come without cost, and ultimately it's women and their families who miss out at the end of the day when local government is kind of put under pressure in terms of equal pay liability. Thank you.
Thank you so much. Ken, I see you've made a couple of comments in the chat, but he's just left. So he left his comments before leaving. Perhaps I'll come back to that. I wanted to really, it's a sort of comment really about what I've taken away from what both of you have said, and something that I kind of hadn't realised to the extent that I have now, having listened to both of you, which is about how all of those reviews really talked about the need to shift away from individual solutions and an individual approach, but never really sketched out what that might look like. And that's kind of where we are. And yet you can see, obviously it's huge. All of these things are really big, and all of them will necessarily come up against resistance in various forms. But I think what both of you have shown is how important it is to understand that those individual claims are situated within wider pay structures and organisational sectoral contexts. So really, really good presentations. So can we ask with raised hands if anybody else has got any questions? I'm just quickly skimming through speakers to see if anybody has any. Can't see any.
I cannot see the hands, but I do have
Okay.
a question or comment. My name is Marta de Bruxelles, and I'm a regional organizer and assistant within the GMB. And one of the things I notice when you're trying to deal with equal pay and trying to motivate people to look into the pay, and especially females in female-dominated working environment, is that emotional pull employers use and the community use, because for most of them, what they express is the fear of going on a strike, participating in any campaign that will lead into it, and the impact they will have, for example, in the schools and the community. So they're always putting the community, the service users first rather than themselves. And it's something that I have 6 years of experience as an education convener and now 2 years of experience as an regional organizing assistant. And when you explain the cost and what they're losing, and like Meg was saying, they work longer hours, they stay behind, they do more tasks, they are working overtime and pay, and when they're getting paid, they're getting literally peanuts. They performing duties for as a teacher, and they are getting not even half or a quarter of a supply teacher will get. So if a supply teacher gets paid £16 an hour, a TA can get paid under £1 an hour for the same job. And that is a reality. And when you explain all of that, how much they're losing, the response is, oh, but what about the community, my children's, my neighbors? And you have to remind them, are they going to be there to pay your taxes, your national insurance, your pension? And that emotional pull is one thing that employers use a lot in order to keep them in that position to say, we can't afford it, we can't afford it, we can't afford it. And trying to say, employers, for example, say, you don't have the same emotional connection if you're working for ASDA or maybe working for the council. So when you work for ASDA, you're more likely to participate in a pay claim because they are big corporations, they have the money, you see that they're making a profit. When you're trying to tell that to a teaching assistant in a small village, believe me, they see you like the bad person. And that to me is a mega frustration. I've been doing this for years because I can go in an NASDAQ or a similar, for example, we're doing, beans and local authorities and other, and you can get the people out. By trying to do that in a school, is a real thing. And the other thing is that conditioning
Well,
that.
so sorry, could I, if perhaps we'll come back to you if we've got. Could I
Thank
just
you.
collect a couple more questions because Anne Henderson and Michelle McNichol have their hands up, and I've also got a question from Charlotte about the impact of motherhood. So perhaps we can sort of keep those and then ask our speakers to come back to all of this later. But thank you. That's a really important point about the female-dominated sectors and occupations.
Sorry.
Yeah, so thank you. Thanks for both the presentations, much to think about still. Yeah, so I'm in Scotland. I guess one of the, so long story, but short, 2 questions quickly. The first thing is around really I'm watching from here, the Birmingham dispute. And it feels to me, as the headlines around the bin men, it feels to me very much what Sally said right early on in her presentation about the man is the breadwinner and the wages of these men are more important. Now, I'm guessing from afar and listening to what Megan was saying that the background to what's happening in Birmingham is around like there would be a consequence if the bonuses remain in place. There's a consequence for levelling up for women workers in the council. And I'm just interested in how it's playing out. They've been touring around Scotland raising money for the poor old bin workers and all that. I'm not saying that we should be arguing for lowering wages, but the way it's being played by the national trade union movement comes across, I think, as only part of the story. So I guess it's a question. Is it only part of the story? Why are we not hearing more about the actual background to the whole dispute? And within that, where do women fit? And then the second question really is around, I mean, this thing around pay and transparency, which featured in both presentations, is so important. And it's really a question for Megan. I'm in the GMB. I was around some of the discussions in Glasgow, and I remember going to the Scottish Regional Council and asking why non-disclosure agreements had been part of the equal pay settlement in 2018, 2019 for the women. And I just ask that question again, really. I think that on the one hand, where we argue for pay transparency quite correctly, I think I was concerned to learn that NDAs, the women didn't know how each pay had been calculated for each of their settlements, and they'd all signed NDAs. And the shop steward, one of the stewards, said to me, "Oh, don't worry about it, Anne. Everybody's just happy to have got some money after all these years." But I don't think that's good practice. So it's really just a question about kind of where that's got to, because I still think Glasgow's still not, the unions appear to still be negotiating job evaluations. It's still not signed off, which presumably means there's a whole batch more claims to come, which are harder to do accurately if NDAs have been signed, I would think. Anyway, thanks for the presentations. Thoughtful time.
Thank you. Thank you, Anne. Michelle, did you want to come in with your question? I want to give everybody a chance at least to ask the questions.
Thank you. And I think both of the presentations were amazing. So thank you to both speakers. I guess my question is probably directly for Sally, or others may have some answers on this, but I'm really intrigued to understand when the official language stopped being about equal pay and started being about gender pay gap, gender pay reporting, and what the impact that change in language has had on addressing equal pay effectively.
Sorry, I'm just listening to the end of the seminar.
Thank you.
Wow.
Sarah.
Quite interesting.
You're coming in on, you might want to mute yourself, Sarah. Just quickly, Linda W, you've got a hand up. Do you want to come in quickly? It'd be nice to get views back.
Yes, thank you. Both presentations really interesting. I'm a historian and I've worked on women's issues in relation to employment in the later 19th, early 20th century. And I'm really struck at how these issues are still so current and so unsolved over 100 years later. But what my question for Sally is, you pointed to one particular industrial action which provoked legislation or helped to raise a dialogue about the legislation that was needed, the Equal Pay Act. Were there wider attitudes at the time? In other words, were there wider influences which were creating a conversation, a discourse about the need for equal pay in the late 60s, early 70s? Because in the later 19th, early 20th century, you had specifically women's trade unions, which were very active on these sorts of issues. The First and Second World Wars also created a platform for dialogue about equal pay and also minimum wage as well. So what is particularly happening in the late 60s and early 70s, whereby these sorts of issues are coming to the fore again?
Thank you. I don't think I'm muted now. Sally, lots of questions, and Megan also. Do you want quickly to come back? And maybe Megan, you need to get in touch with Anne to carry on the conversation about Scotland.
Yeah, shall I pick up the ones that were directed at me? That was a really interesting question, Linda, and a really big one, and I'm not quite sure I can do it justice, but you've really made me think. and actually made me think when I was really sort of fully involved in everything to do with equal pay in the 2000s. I remember at the National War Museum there was films being shown. I went to see, there's a short film made by Jill Craigie at the time in 1940s about the battle for equal pay. And I remember going to see it and being absolutely blown away that all these things that I thought we were just discussing now, you know, she was capturingly brilliantly, and very emotively as well. Back then, there was sort of brilliant, you know, her pulling apart the argument that a man's wage is a family wage by following a woman who's, you know, lost her husband in the war, and was, you know, barely surviving, supporting her child. You know, I wonder if it was just one of those moments where, you know, it was the right. I'm sure there was lots of other influences going on at that time. I wonder if it was the right sort of industrial action. You know, Ford was a massive plant. It caused a lot of disruption, and you also had Barbara Castle in a position of power as well, to act. What was the other question I had about the shift from equal pay to talking about gender pay? So I think it is on the positive of talking more broadly about the gender pay gap is that it sort of encouraged action on some of the broader things that affect women's pay, or had the potential to encourage us to think more about some of the broader things that influence women's pay and employment opportunities. But I do think it has created some confusion, and particularly with the gender pay gap reporting regulations coming in, sort of off the back of all of the everything that was going on around equal pay at the time. Sort of working with employers now, I think you always begin your gender pay, and almost every gender pay gap report I've looked at from employers begins by explaining that it's not the same as equal pay. And generally the narrative as well is then identifying all of the broader issues, and there isn't that focus on actual pay equity. But having also worked in law and medicine, and this picks up another question there about the motherhood. So I think in lots of professions, sometimes it makes sense to focus more on some of those broader gender pay gap issues, because, for example, when we did the gender pay gap task force in medicine looking at doctors, women were getting equal pay. The unexplained part of the gender pay gap was very small, but there were massive issues for women doctors about, you know, entering the profession, then really poor support around having children, often during their training contracts. And then often they would change specialty. They'd go from a hospital specialty to general practice, have to go back, you know, some years in their training to qualify as a GP, because that's where they could get their flexibility. So there were much bigger issues than around, you know, women's pay and employment opportunities that needed to be addressed, rather than probably the equal pay within the pay structure. Yeah, but I think I agree that it has made it much more difficult to focus on pay equity.
Okay, Megan, last word.
Sure. I'll try and be brief and answer a couple of Anne's questions, and I'm happy to carry on the conversation if you'd like after. In terms of the Birmingham dispute, I think there's quite a lot reported in the news, and we have proposed to the council and to other trade unions the option of leveling women's pay up. And actually, you know, I think without having costed it for the council, it would be potentially a feasible option for them. I think unfortunately, the conversation around different disputes involving equal pay have become quite toxic. And for us, it's there's a consideration for us around our members and them achieving pay justice and how we approach things in the media and in the press, and politically. I mean, more so in the media and the press, I guess. But in terms of, it can be hard because oftentimes women will get blamed for council's finances when they pursue equal pay. And that's really true in Birmingham, considering the commissioners coming in and the Section 114, and the conversation is very nuanced around that. I think I'm probably as shocked and confused as everybody else would be in terms of how some other parties, I don't know, approach the table, I guess, is to put it politically correct. Yeah, we're quite laser focused on ensuring that our women members get what they're owed in terms of equal pay. And if other people around the table can't see that, then we do our best to convince them, and we are always doing that. Yeah, in terms of non-disclosure agreements around equal pay, there are confidentiality clauses. There's a variety of reasons for them. I don't think they're technically non-disclosure agreements, although that's not my area of expertise. So I'll caveat that with I'm not 100% sure exactly what that would be called. In terms of confidentiality clauses, there are reasons why that some of that stuff is in there. They should be given information around how their offer is calculated, and their different campaigns and different agreements look different. In terms of what we're negotiating right now around settlements, everyone will have a like a breakdown of how their claim is valued, essentially, and an opportunity to look at that information. So it shouldn't be, so when it comes to doing it again, it's quite straightforward, to be honest, where we know what was calculated on the first time, and we can look at that. And there may be some changes based off of what we can negotiate, because we'll always try and get the best deal for our members. But confidentiality is a tricky one in terms of members speaking to the public about what they're offered. There are safety concerns around that as well, because lots of times people will be getting, there were six-figure sums, payouts in big campaigns in Glasgow. That can pose a risk especially for women. So we try and navigate those as sensitively and carefully as we can. Thank you.
Thank you very much. So I guess not to make us all late for our dinner, we need to stop there. But thank you so much for two really, really, really interesting and informative presentations, and also really thought-provoking. I'll be thinking about this for quite a while afterwards. So thank you, everybody, and especially to our two speakers. Amazing. Thank you.